Now, programming from the Illinois Channel, an independent, nonpartisan corporation formed to provide nonpartisan coverage of Illinois state government and other public affairs events taking place across Illinois. For more information on the Illinois Channel, please visit our website at www.illinoischannel.org.
Just ahead, Governor Rauner holds a press conference alongside a task force he assembled to fight health care fraud at all levels of government. Governor Rauner and the task force report on their work and savings made. Then in about 20 minutes from now, former Governor Pat Quinn gives a speech at the City Club of Chicago titled A Democracy Agenda for Illinois. He also talks about his work with Take Charge Chicago and a petition he supports to enact term limits on the mayor of Chicago. Following that, in about 50 minutes from now, State Senators Andy Manar and Sam McCann hold a press conference to discuss legislation they're supporting that would prohibit executive branch appointees from participating in or influencing elections. And finally, in about 1 hour and 5 minutes from now, we sit down with Christopher Hurley, the president of the Illinois Trial Lawyers Association, and talk about the types of cases a trial lawyer would take, why he says class action lawsuits are necessary, and the effect of workers' compensation on Illinois job growth. That's all just ahead, after a brief word from one of our advisory council members.
Hi, I'm Dan Montgomery, president of the Illinois Federation of Teachers. More than 100,000 IFT members work each day in schools, universities, colleges, and state agencies across Illinois. They're professionals who teach our students, keep our public buildings safe and clean, and provide critical state services, and much more. As an advocate for our members, their professions, and those we serve, the IFT works in Springfield to support legislative policies that promote high-quality schools and public services. We also fight to protect collective bargaining rights for all our members and all working men and women. We do this through an organized program of advocacy and year-round monitoring of public policy proposals. And that's why the IFT is proud to support the work of the Illinois Channel, whose coverage connects us to legislative debates and committee hearings, as well as interviews with leaders on key issues like the state budget, tax policy, public pensions, and education funding. Funding education is one of the primary responsibilities of Illinois state government. So we should all pay attention to the policies being proposed and how they may help or harm our children's futures. You know, what's happening in the State House today directly impacts what happens in classrooms tomorrow. And what happens in classrooms impacts the future of our state and our nation for decades to come. I'm Dan Montgomery, president of the Illinois Federation of Teachers, and I'm proud to serve on the Illinois Channel's Education Advisory Board. The Illinois Channel, it keeps us all connected.
Next, from Chicago, Governor Rauner holds a press conference alongside a task force he assembled to fight health care fraud at all levels of government. Governor Rauner and the task force report on their work and savings made. This runs about 20 minutes.
Every dollar that we can save in government operations and cost to taxpayers is a dollar we can put into our schools. It's a dollar that we can put into services to help our most vulnerable families. And it's a dollar that we may not have to spend so our small businesses don't have to bear unnecessary tax burden and we can grow more good paying jobs. Government effectiveness and efficiency, critically important. And this has been a core part of our administration from day one. We're very proud of the accomplishments we've made so far. As you know, we have made major strides in changing our IT systems in state government. We have been inefficient and wasteful in our IT. Many of our departments and agencies don't even have computer systems. And that drives up costs, that drives down productivity, and we're transforming that. We've already improved more than any other state in America on the way that we do IT and the digital services we've delivered. We have also helped streamline our government and found waste and inefficiency in virtually every department, and we're increasing productivity. It's very exciting. Healthcare is one of the biggest sources of spending, but ineffectiveness and waste. Unfortunately, in our healthcare system, we do have fraud, we have abuse, we have inappropriate payments. The federal government has estimated that roughly 6% of all spending in Medicaid is inappropriate. It's either wasted, or it's overpaid, or it's subject to fraud. 6%. That's on $548 billion at the federal total. Think about 6% on that. It's a lot of money. Here in Illinois, we spend $18 billion on Medicaid. 6% of that is almost $1 billion. Think about that. That's a lot of money we could put to help our most vulnerable, our autistic, our developmentally disabled, our veterans, homeless. Our vulnerable could use that money, and our schools. Too many of our low-income schools are underfunded. We could put this money to very good use. So finding waste in Medicaid and inappropriate payments, critically important. But health care is also very expensive, both for our state employees, our health care services for our state employees, very expensive. And there's a lot of inefficiency and waste there. And also in our workers' comp claims in government. Now, we've advocated workers' comp reforms for state government as well as for private business. Workers' comp costs are exceptionally high in Illinois, and that hurts taxpayers. That drives up the cost of government. So earlier this year, we formed a task force. Many of their members and leaders are here with us today. Task force to look at health care fraud in all levels. Medicaid, state health care for employees, as well as our workers' comp system. And we have already found extraordinary savings. I'm very excited. The task force put out his report. That's what we're here to summarize today. But to give you a few highlights, before our administration came into office, prior administrations were finding $90 million, $80 million, $94 million per year of overpayments or ineffectiveness. We found $220 million on the first shot through. $220 million of overpayments or savings opportunities. We also found $17 million of clear cases of fraud that we're able to go after and recoup. We've also found $22 million in savings in our state employee health spending last year. We found $32 million more in savings this year. Huge number. And the task force report said there's another $50 million in Medicaid that they've identified right now that we can go after and get very quickly. These are transformative numbers. This is money that now taxpayers aren't spending on necessarily. This is money we can put in to help our families that deserve it and really need it, and also to put into our school system, because we've got to improve our school funding in this state. So this is an exciting time. At this point, I'd like to turn it the podium over to Maggie Hickey, our Administration's Inspector General. She's the chair of our task force, and she can comment with some more detail. Maggie?
Thank you, Governor. Thank you very much, Governor. I'm Maggie Hickey. I'm the Executive Inspector General, and it's been an honor to serve as the chair of the Healthcare Fraud Elimination Task Force. I want to thank the task force members for their hard work, their expertise, and devoting their time to this important endeavor. Healthcare fraud, waste, and abuse is rampant in Illinois, and this task force is a great opportunity for the state to improve on its current efforts, ensure that taxpayer funds are not used for fraudulent and wasteful purposes. During our initial 6 months, the task force focused on understanding the current resources and systems used to address healthcare fraud and abuse and waste in Illinois, and developed a strategic plan to save taxpayers in the most efficient manner. We gathered information from our members, other state agencies, industry experts, and including the federal experts from the U.S. Attorney's Office and HHS, and also our managed care organization partners. We also looked at the current use of state resources to address waste, fraud, and abuse. The task force then divided itself into 3 working groups focused on Medicaid, workers' compensation, and the state employee group insurance. The task force then developed a focus for these working groups, and we focused on 4 areas: collaboration and coordination, data analytics and metrics, accountability and efficiency, and most important, safety and wellness. One key takeaway from our information gathering is that while addressing fraud after it occurs, commonly known as the pay and chase, is important, but big savings can be realized in fraud and waste prevention. Stop the fraud before the state pays the money out. The task force also recognized that improved data analytics and collaboration amongst agencies is a big part of Illinois moving forward with their fraud prevention efforts. During the task force's initial meetings, it became clear that information, resources, and efforts to address fraud, waste, and abuse in state-administered programs were, for the most part, isolated within the agencies, operating in silos. The task force facilitated regular meetings amongst the agencies that have similar programs or work with similar providers in order to more efficiently identify and address fraud, waste, and abuse. The task force also launched targeted initiatives for certain programs that were cross-agency, such as a managed care initiative and an in-home care initiative. The discussion today is about our first 6 months and what we learned. Going forward, we will continue to collaborate and implement the best practices to save Illinois taxpayer dollars while providing quality care. I now will look forward to hearing from other task force members, and I turn it over to Felicia Norwood, the Director of HFS and a fellow task force member.
Thank you, Maggie, and good afternoon. As the Governor mentioned, the Illinois Department of Healthcare and Family Services spends over $18 billion every year in its Medicaid program. We are the largest insurer in the state, insuring over 3.2 million individuals. That's 1 out of every 4 people in this state. We take healthcare fraud, waste, and abuse very seriously. As all of you know, just recently, last week, the state of Illinois submitted an 1115 waiver to the federal government. That waiver is going to allow us over a 5-year period to bring in an additional $2.7 billion into this state. We are trying to transform the way that we provide services in the state of Illinois, in the Medicaid program, focusing early on behavioral health. An important aspect of this is paying for value. In the Medicaid program, we have typically paid for volume. Fee-for-service has been the way that we've typically delivered services. We don't plan to do that going forward. We are migrating to a system that pays for value, quality, and outcomes. That will be a key component of our ongoing efforts to address the issues of waste, fraud, and abuse in this program. We believe that every dollar spent in the state Medicaid program should go to those individuals who need it most. And those are the individuals that are the most vulnerable in this state. This department is honored to be a part of this effort because we believe that the taxpayers and our Medicaid beneficiaries should expect us to make sure that valuable resources are going to the place where they're needed most, which is to those who are in the care of this state, in this department, for core healthcare services. Thank you very much. At this point, I want to turn it over to Brad Hart. Brad is the Inspector General for the Department of Healthcare and Family Services. He works in partnership with all of us in trying to make sure that we are maintaining the highest standards of program integrity within the Medicaid program. Brad?
Thank you, Director, Maggie, and Governor. Thank you. As the Inspector General over the Illinois Medicaid system, I'd like to add my wholehearted support to the Governor's task force and its objectives. The Medicaid Inspector General's office has been diligently working over the past 5 years to build a partnership with all entities that direct, regulate, and participate in the Illinois Medicaid system. OIG's efforts have led to increased use of best practice data analytics, increased education of providers and recipients, increased return on investment for the taxpayers of the state of Illinois. In the very near future, we will be putting out our fiscal year 2016 annual report, which will depict cost savings, recoupments, and cost avoidance in excess of $220 million. While we have made great strides to become a national leader in the realm of Medicaid program integrity, there's still much more that we can do. The task force report highlights some of those areas where all of the entities involved can work better together to achieve the greatest return for the taxpayers. Over the last 5 years, OIG has enhanced our audit processes, continued development and use of analytics to identify fraud, waste, and abuse, generated initiatives that recouped overpayments from many different provider types, enhanced our administrative sanctions of providers that commit fraud, waste, and abuse, enhanced our relationship with local, state, and federal law enforcement agencies, educated providers on the rules and regulations surrounding their submission of claims, implemented a very successful self-disclosure protocol, and further pursued our motto of accuracy, fairness, and transparency. In the future, OIG plans to pursue the recommendations of the task force by increasing the amount of data upon which we can perform analytics, continue to develop our best practices analytics system to help identify fraud, waste, and abuse, increase and refine our audit plans to make sure our audit processes are as efficient as they can be, increase our capabilities to pursue highly technical professional investigations, increase self-reporting of overpayments by providers, increase education of providers and recipients so that they do the right thing to begin with, and continue the development of initiatives to attack vulnerable areas of fraud, waste, and abuse within the Medicaid system. Therefore, I look forward to working with the task force membership to make sure that taxpayer dollars are efficiently spent to help those that need assistance and to pursue those that would abuse the system for their own benefit. I would turn it over now to Hardik Bhatt, who is the Secretary of the Department of Innovation and Technology.
Thank you, Brad. And thank you, Governor. It's been a privilege for the last 18 months to be able to serve the 13 million Illinois residents here. And basically, you know, I'm not saying this because I work for this administration, I work for the governor, I work for 40 different cities, work with 40 different cities globally, Barcelona, Chicago, Hamburg, Dubai. And this is probably the right time, the right leadership. This is the administration that really understands the power of technology to enable the government, to enable the customer service. And basically the governor proved that earlier this year when he brought all of the disparate technology resources across the state together to create, first time in the history of the state, the Department of Innovation and Technology. We all came together, and now we are working for enabling our business. And we are trying extremely hard, working extremely hard to come through with the promise of transformation. As the governor mentioned, in the last 18 months when we started, Illinois was ranked in the bottom 4th of all of the 50 states in using technology and giving outcomes to our businesses and to our customer to provide better services. In the recent rankings that were released in September, this is a neutral ranking that comes from the Digital States Survey, Illinois was ranked in top 3rd of the 50 states. So from bottom 4th to top 3rd in 18 to 20 months, and we are continuing to move forward. We delivered, first time again in the history of the state, a unified financial management system, and we are moving towards adding more agencies to that. We have created a platform that can now allow us to roll out a mobile app every month. But I think the biggest breakthrough is just by having technology sitting at the business table, talking to the people who understand business, who need technology to enable them, we've been able to break through. One of the things that is very stereotypical about governments is we all feel like, you know, this is my system, this is my data, I cannot give that to you, even though that data actually belongs to the customer and we are all collecting that. We've got hundreds of systems that keeps this data in silo, and it doesn't make sense if you're only looking at that from that myopic view. So what we did, Indiana is considered to be one of the leading states in using data analytics, and it took them 18 months to create a data sharing agreement among all the agencies and technology. We did that. We learned from them. We give credit to them for that, and we did that in 7 months. 13 agencies came together, signed an enterprise data sharing agreement, and now we can go across all of these agency silos and system silos, share data, and see what's going on with our customers. How can we improve the service that we are providing to them? At the same time, how can we make sure that we can reduce the wastage that's going on in the taxpayer resources? I believe that as a technology executive in this administration, my premier job, because I'm getting paid by the taxpayer dollars, is to save every tax penny that I can. And I'm very fortunate and privileged to be working with the task force members to enable them to do their work. Again, thank you very much. It's a pleasure and privilege to work on this important initiative. And let me turn it over to Captain Brian Lee from the Illinois State Police. He leads Medicaid Fraud Control Unit for Illinois State Police.
Thank you, Hardik. Good afternoon, and thank you, Governor, for allowing me the opportunity to speak today. Thank you for allowing me to represent the state police on this task force, and thank you for your commitment to eliminate fraud, waste, and abuse from healthcare programs throughout the state of Illinois. As the director of the Medicaid Fraud Control Unit, I bring the enforcement aspect to the task force. It's my responsibility to share with the other state agencies the fraudulent techniques and schemes of those dishonest medical providers involved in the Medicaid program. For example, I have shared some investigations of medical professionals who submit claims for medical procedures that never occurred. medical transportation companies who submit claims for service for transporting individuals, and those individuals had passed away months before. And lastly, home care assistants who claim they are providing services for vulnerable individuals, but they don't show up to provide the much needed care, yet they turn in a timesheet and expect to be paid timely. Sharing this knowledge provides our experts the opportunity to fine-tune the systems within our control and to ensure it doesn't happen again, or at least make it much more difficult. The Executive Task Force is doing exactly what state agencies need to and should be doing, working collaboratively, sharing resources, and discussing ways in which we can become more efficient and more productive. Quite often we see task forces created and the result is simply pen on paper. I can attest, after numerous task force and working group meetings, emails shared amongst the members, and attending our 2 public meetings, this is an active task force, and I'm confident fraud, waste, and abuse of our healthcare systems can be significantly reduced as a result of our collaborative effort. The 6-month task force report recently published reflects 42 fraud convictions and nearly $17 million in recoveries from federal fiscal year 2015 as a result of our criminal and civil prosecutions. I'm pleased to report that for federal fiscal year 16, that number has grown to over $21 million in recoveries and 40 fraud convictions. State police investigators and intelligence analysts are passionate in thoroughly investigating allegations of fraud, neglect, and abuse of the Medicaid program. Again, Governor, thank you for this opportunity. And my final comment is more of a request for the citizens of the state of Illinois. At some point in our lives, we all receive some type of medical treatment. It's incumbent upon us all to review the claims and the payments for the services we and our families receive. Please take the time to review the medical statement for accuracy, whether you're paying them, the insurance company is paying them, or a government program is paying them. If we can stop the fraud, waste, and abuse together, the end result will be better, more efficient health care for you and for our loved ones. Thank you. Governor.
Thanks, Brian. And I want to say thank you. Thank you. We're very blessed in Illinois. We have wonderful public servants leading our departments. I'm very proud. I believe we have the best team ever assembled to help run a state government. I'm honored to be their employee. I work for the people of Illinois. We all have the privilege, the honor of doing that. Felicia Norwood, Hardick Bott, and their fellow directors and leaders. Maggie, thank you. They're outstanding. Great public servants. And this initiative, critically important. I personally believe in the next few years we're going to save hundreds of millions of dollars more than the $270 million or so that we've already saved in our healthcare system, provide higher quality services, and get those dollars to the families and the individuals who need it the most, and get the money where it belongs, not into waste and abuse. And this is very exciting. This is a very critical initiative. With that,
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.
Next from Chicago, former Governor Pat Quinn gives a speech at the City Club of Chicago titled A Democracy Agenda for Illinois. He also talks about his work with Take Charge Chicago and a petition he supports to enact term limits on the mayor of Chicago. This runs about 30 minutes.
Well, thank you very much to Jay Doherty and to the City Club and to everyone who has come here today. I was here last on January of 2015, right before I left office, and I was always grateful to the City Club for the opportunity to speak about important issues and to answer questions and to visit. I think all of us miss Paul Green. He was here that day, and he was just a mainstay, a man for all seasons, a fellow who really he helped educate all of us. He was a professor, but he understood that his classroom was far more than just a university. It was all of us, and he talked about democracy. So that's my topic today, but I did want to salute Paul and also Tom Roser, who's passed on. Tom was a good friend, and with Jay, they really put vitality into this organization, and it's so important, I think, to our state and definitely here to the city to have a place where you can come and talk about important issues, defend your position, and also listen to others. So I want to thank the City Club and all those who have come to these luncheons and breakfasts over many years for your interest in democracy. It so happens that today, October 18th of 2016, would have been my mother's 99th birthday. She passed away. My mom passed away last November at 98 plus, and when you really think about it, she was born in 1917 when women did not have the right to vote in America. That was before the passage of the Constitutional Amendment in 1920. So a lot of things happened in her lifetime, especially expanding the right to vote, the opportunity to participate. Whether you're a person of color or someone who was 18, we had to pass important laws and constitutional amendments to make sure that the opportunity to really participate by voting in a democracy was protected and expanded. And in fact, when I was governor, I signed bills for online registration for people who wanted to register to vote by using the internet. We also were able, right before I left, to sign a bill that allows people to register on Election Day. And that happened back in 2014. And this spring in the March primary, literally thousands and thousands of people use that opportunity. So I think it's very important, and I do support automatic voter registration, where you renew your driver's license or some other act with the state government that you would automatically be registered. And I want to salute all those. Chicago Votes was very involved in that with many, many more people. Joyce Foundation helped. I think George Shung is here. It's very important that we keep expanding the opportunity to participate in our democracy. And then today, before I get started on petition drive that I'm directly working on, I did want to salute folks who have been in the vineyard of petition passing for a local binding referendum right here in Chicago. It's on the west side. It's called the Community Expanded Mental Health Program. I think we have Mike Schneidiger and Robin Watson. Why don't you guys stand up for your good work? As you know, there have been cutbacks in mental health clinics here in the city of Chicago, and the bill was passed, put on my desk, and I signed it into law that allows citizens to petition in their neighborhood to establish a mental health district for expanded care, to make sure that everyone would have free mental health care if they had nowhere else to go. And my friend Pete O'Brien is here today with the Kennedy Forum. He's very, very involved in mental health initiatives, and we've already passed one of these expanded mental health districts in Chicago on the north side, and Mike and Robin are working on a referendum that's going to be voted on November 8th on the west side. And I think we need to keep doing this in every part of the city of Chicago, because it is a local binding referendum that people can put on the ballot. They decide whether they want to have a modest tax increase in order to fund this mental health district. But there's hardly a more important issue on health care than making sure we have parity with respect to mental health and physical health. And I really salute folks in the neighborhood who gathered 10,000 signatures on the west side of Chicago to make this happen this year in this election. And also on the ballot, county-wide, it's an advisory referendum, but it basically calls on our state to have earned sick leave for all the workers of Illinois, for people who are working hard, who have not one sick day. There's something wrong with that. If somebody gets sick or a family member gets sick, we ought to have earned sick leave in our state as the law. And two years ago in Massachusetts, it was an initiative on the ballot. The whole state, they passed it into law. It's now the law of the land in Massachusetts and a number of other states around the country. And I want to thank Ron Powell of the United Food and Commercial Workers. Why don't you stand up, Ron, for your efforts in this area. Thanks to Ron and many volunteers, it was passed by the City Council, and just last week the County Board for Cook County. But we have a lot of other counties in Illinois, 101 counties, and using the power of petition and referendum, it is a good way to have the voice of the people heard. Andrea Rayla, who's in the back, and William Morgan, who's here, they both went out and led a petition drive to put the earned sick leave referendum on the Cook County ballot, calling for this to be the law of Illinois. And I know something about that because in 1982, we did a similar effort for a petition and referendum for the Citizen Utility Board. I brought the original envelope of the Citizen Utility Board. I noticed Commonwealth Edison didn't come as much today. I don't know why. But it's a very fine company, and I like the people there. However, one of their lobbyists, who I'm sure has since retired, told me back then when we were putting Cub on the 1982 ballot, Illinois' largest consumer group, it's been around now for a third of a century, he said, Quinn, in 1,000,000 years, that'll never pass in Springfield. We'll kill it. And it passed in 1 year because we used the power of referendum to get it on the ballot for the people to speak. And we went all across Illinois, not only here in Chicago, but across the state, giving voters a chance to vote for a consumer group that would represent their interests when it came to utility companies. And so I think that shows, again, what people can do when they put their minds to it as far as passing petitions and having referendum votes on issues as well as candidates. And that's why I did want to speak about a very important petition drive that occurred in our state this past year or two. It was put together by a lot of well-meaning, hard-working citizens of all different backgrounds, Democrat, Republican, Independent, all regions. They understood that redistricting reform was necessary in Illinois and wanted to put it on this year's ballot. Well, there were obviously some challenges there, and the Supreme Court decided that it didn't meet the exact specifications of the Illinois Constitution. But I want to tell, and I know she's here today, Christy Hefner and Rod Joy is here, who are involved in the movement and organizers of the movement. Don't give up. It's very, very important, I think, for those citizens of Illinois who want to vote on this issue, that in the next election, in 2018, we can put redistricting reform on the ballot. We may have to revise the petition a little bit, but it can be done. More than 500,000 people signed that petition, and it is quite sad that we aren't going to have a chance to vote in a binding referendum this fall on that. I know 40 years ago, I passed a petition all across Illinois to have ethics put into the Constitution. For example, ending advance pay for politicians, stopping double dipping, preventing conflict of interest voting. We gathered 635,158 signatures, the all-time record in Illinois. But when we filed our petition, there was a challenge. The insiders are always going to challenge you. And the court held that ethics could not be put on the constitutional statewide ballot in Illinois. It was a severe disappointment. At least in that year, we were able to get a statute passed that ended advance pay for legislators in Illinois. For 100 years, legislators would get sworn into office and collect their entire annual pay on that first day before they did a single day's work. If they retired and resigned, they still kept the money they took in advance. If they went to jail, as some of them did, they still kept the money they took in advance. And people didn't like that. The bill to end that practice was defeated in committee 17-3. Matter of fact, the sponsor of the committee, his nickname, he was a rookie, was Bad Bill Byers. He put in a bad bill to end advance pay. But we, the people, gathered signatures on a petition. And while we didn't get a constitutional amendment, we did get a law passed against that practice. And when I got introduced to the General Assembly that year, a fellow named Mike Madigan was presiding at the time. They were introducing the 4-H Queen from Macomb and the Cub Scouts from Carbondale, and then somebody pointed up and said, there's that Pat Quinn up in the gallery. I got a standing ovation of 3 minutes from the members of the General Assembly. So you got to have a tough hide. And I would say to all of those who work so hard and diligently on the independent maps movement, redistricting reform can happen in Illinois. And I drafted a measure that's simple and clean and pristine. It's very simple. And I think that's the best way to meet the court test. The court did not say redistricting is off limits for constitutional initiative where the people can pass petitions. And after we lost that battle in 1976, we came back in 1980 and gathered almost 500,000 signatures to put a referendum on the ballot that reduced the size of the Illinois General Assembly, the House. And that was on the ballot, and the people voted for it, and it was binding. And it was the only time in Illinois history, in the whole state history since 1818, that voters have been able, by their petition, to put a binding statewide referendum on the ballot. I think we can do better than that, because Illinois' bicentennial is in 2018. 200 years, one binding referendum that is initiated by the people of Illinois. All over the Midwest, all over our country, people are voting on important issues that they themselves have petitioned onto the ballot. And so I really hope to work with folks here and everywhere that we can, in our bicentennial year of Illinois, make that a year of voter democracy in Illinois, to open up some of the roadblocks that have been erected over 200 years so citizens don't have a chance to vote on binding questions. For example, we had an advisory referendum on raising the minimum wage in 2014. I signed that bill to at least give voters a chance to give their advice. But in Arkansas, and this year in 4 other states, Colorado and Maine, and I think the state of Washington, Arizona, they're voting on whether to raise the minimum wage, and the people make the law. And we should have that same right here in the land of Lincoln, government of the people. And that's why I'm involved right now in a petition drive for a binding referendum in our city of Chicago. Because when the drafters of the Illinois Constitution did their work and was ratified by the voters in a referendum in 1970, this is our Illinois Constitution, they did for the first time give some binding referendum powers to voters at the local level, at the municipal and county level. This was unheard of in our state, but basically the drafters of the Constitution felt that sometimes the people in power at a local office would become too accustomed to their power, concentrating their power, and not letting a lot of fresh air in. So it was put into the Illinois Constitution in the local government article, a binding referendum initiative process where voters at the local level can put term limits on their local officials. They can also change officers in their local government from appointed officers to elected officers in order to make sure the voters were in charge of their local government. Now, this has been used in Illinois in 20 different cities, in places like Springfield, where Jackie's from, and Naperville, and Oak Lawn, and Des Plaines, and on and on. Many, many communities of Illinois have used the power that's already outlined in the Illinois Constitution to put term limits on their mayor. Usually it's a two-term limit, similar to what the president has, and it's worked very well. And matter of fact, this election in Cook County, there are 4 communities voting on that exact referendum in their towns. In addition, around the country, if you look at the 10 largest cities in America, the 10 biggest cities, all of them have term limits on their mayor, except one city, Chicago. New York has term limits on the mayor, Los Angeles, Philadelphia, Houston, San Antonio, San Diego, San Jose, you name it. People have, I think, especially when it comes to municipal offices, the office of mayor, recognized that having a 2-term limit is a good way to go to avoid any one mayor concentrating their power. Especially in this age of super PACs and big money in politics, it's better to have what the play Hamilton points out very clearly with George Washington. He could have been, I suppose, like King George III in England. King George III was on the throne for 59 years. And he was amazed, King George, that George Washington of the United States of America voluntarily stepped aside after 2 terms as president. He couldn't get over it. But Washington understood that we have a democracy, that we don't want in a democracy to have a House of Lords, that we don't want concentrated power. The founding fathers called it rotation of office. And people like Jefferson and Madison and Hamilton and Ben Franklin all believed that no one person should have the same office for too long, and 2 terms were enough. And so I think that's something we should really think about here in the city of Chicago. At the same time, we're passing petitions to put this on the ballot. We need to get 52,519 signatures by December of next year to give voters a chance to vote on this in the next election. We hope to get at least 100,000 signatures, and while we're gathering signatures for term limits on the mayor, we're also gathering signatures on the same petition to establish an elected consumer advocate in the city of Chicago. Now, in New York, they have a public advocate who is elected by all the voters of the city of New York. Matter of fact, the current mayor, Bill de Blasio, used to be the elected public advocate. And the public advocate in New York, similar to what we're talking about, we call a consumer advocate, is someone who is an ombudsman, a word in Swedish that means the people's person. Someone you can go to if you have a grievance, if you have something that's falling through the cracks of the bureaucracy. Someone who will stand up for consumers and taxpayers against unfairness and against inequality. I know that it's very, very important to have somebody you can turn to when things aren't going the right way. And right now in our city, we have an appointed person who is the head of the Department of Business Affairs and Consumer Protection. This office used to be called Consumer Services, but now it's called Business Affairs and Consumer Protection. One person they're appointed, I'm sure they're a nice person, but rather than have an appointee of the mayor do that job, we should do what New York City has done for the last quarter century and have an elected person running not only that department, that office, that agency, but also under our petition, we've given the consumer advocate some other duties. One of those duties is to monitor the city's compliance with the Freedom of Information Act, which is a state law, which unfortunately Chicago has regularly not abided by. Matter of fact, 400 days went by before a judge had to order the city to stop stonewalling with respect to a Freedom of Information Act that was very important, that really unveiled something that we all know has to be addressed and solved and resolved. The city did not comply with the Freedom of Information Act after that terrible event occurred on October 20th, 2 years ago. And so there ought to be somebody who monitors their work, somebody in city government who's independent of the mayor, independent of the bureaucracy, who makes sure that information does flow to the people, who are the ones who are in charge of our city government. The same way the city used to have the Department of Environment, and one of their excellent leaders is here today. Currently, they abolished the Department of Environment. I could never understand that. I was Lieutenant Governor of Illinois and then Governor. We had a clean water initiative. We did many things with the department, the Illinois Environmental Agency, Protection Agency. But the city mysteriously ended their Department of Environment. Well, there ought to be someone, the consumer advocate, that fights according to our Constitution to promote a healthful environment for this and future generations. So that, again, was a duty of the consumer advocate. I think it's important to have a person who is a strong voice for our environment, for freedom of information, for taxpayers, for consumers. And so that is something we can put on the ballot at the next election. It would be March of 2018 now. And in order to get that adopted, the people would have to vote in favor of it. So these are two binding referendums. One is term limiting the mayor. The other is electing a consumer advocate in the biggest city in our state, third largest in the country. And part of the reason that I'm involved in this is because I do believe in the power of grassroots democracy. I think we need to expand voting. My mom had a fight to get the vote for women. She was 3 years old, but she got the fight and won, okay? But that was back in 1920. And why don't we, in our city of Chicago and our state of Illinois, get to vote on more issues? Not just candidates who sometimes squabble. Just over the last year and a half, more than a year and a half now, looking at the events in Springfield, what if voters in our state had a chance by petition to put issues on the statewide ballot to help resolve some of the gridlock and controversy that occurs in Springfield? What if voters in Chicago didn't have just an advisory right to urge that there be an elected school board in the city of Chicago, the way they have in 859 other school districts in Illinois, every single one, but could actually enact a law by their petition and referendum votes. I really feel we need to open up the opportunity to vote on important issues, whether it's minimum wage or an elected school board or ethics in government or consumer protection or making sure that we have redistricting reform or making sure that those who are in office don't get the attitude of King George III that they're the ruler and we're the ruled. As President Obama recently said, the history of our country is we don't like to be ruled by people who are in office for too long. We understand that it's important to have grassroots democracy bubble up from the grassroots. And that's what's happening across the Midwest. That's what's happening across America. And it's time to make democracy bloom in Illinois. So in these next 2 years, I intend to work as hard as I can with good people to hopefully have a redistricting reform measure on the 2018 ballot, to have on that ballot an opportunity to put term limits on the mayor of Chicago and elect a person who's going to be a strong consumer advocate for the people of this city. And there's lots of other opportunities to do the same and make the will of people the law of the land. Thank you very much.
Well, there's several people that asked the same question. Tim Egan from the New Roseland Hospital. We need you back in office. What office will you run for next?
Well, I want to thank Tim. I appointed Tim to help rescue Roseland Hospital, a very important hospital, a very important neighborhood. And it needed a strong hand, and Tim has provided that over the last several years. And he's really done a magnificent job saving jobs for the people who worked at the hospital, but most importantly, helping expand decent health care across that neighborhood. And matter of fact, when I was governor, I signed the bill to expand health care coverage in our state. And we've added about 1 million people, thanks to President Obama, Affordable Care Act, and getting that passed in Illinois. And people like Tim are important folks in that. I have run for office. I've won, and I've lost. One day you're a peacock, the next day you're a feather duster, okay? So you don't always win. But you never give up, and you always find another hill to climb. So that's what I'm kind of back to the future. I started passing petitions for referendums 40 years ago, and we've collected, the groups I've been with, over 4 million signatures in that time. But too often, we've been roadblocked, as what happened this year with the independent maps. You know, it's very hard to take that. And so I think we really need a rebirth of citizen action in our state in the next 2 years to put on the ballot in 2018, when we celebrate 200 years as a state, some important reforms that are long overdue. So that's really what I'm committed to. And whether I run for office or not, I don't know. But I know I am going to be committed to expanding grassroots democracy wherever I can find it.
Thank you. I've got a couple questions here. There are a couple of people here who seem to know an awful lot about some non-public things going on in your life, so I'll try to work this in. Jane Johnson, where are you, Jane? Way in the back, City Club member. And the irrepressible Von Steuben High School graduate, Graham Grady. Where are you, Graham? Well, I've got his name on a question. I guess he doesn't want to put his hand up. Governor, do you have a takeaway experience from your race with Rauner that was so close, most people regret now, and do you plan to run again for public office?
Yeah. Well, I was here 2 years ago, and it was a hard-fought campaign. I had signed a bill for limiting campaign contributions. It was the first time in Illinois there was ever any limitations on contributions, and I thought it was a good reform. And we had to sign a lot of legislation and pass reforms after I became governor. I inherited the worst economic recession and situation Illinois ever had since the Great Depression, but we also had an ethics depression after my predecessor was impeached and removed from office. So we had to do a lot of reforms, and one of them, the campaign finance, I thought was a good one. I abided by it, but it did have a provision that if a self-funder came along and broke all the limits with their own spending, then the limits would be taken away in that election. And I always regret that Rauner didn't abide by the limits that I had abided by for about 3 years. He decided he wanted to, spend unlimited, almost infinite money. It was about $70 million. And I don't think that's a healthy thing for any democracy, to have $1 one vote as opposed to one person one vote. And I think really that's one of the reasons I believe so much in petition and referendum, that in this day and age of big money and super PACs, that may be oftentimes the only way voters can get reforms adopted. Rauner was opposed to the minimum wage. I believe in raising the minimum wage, but we only had an advisory referendum, and that hasn't ever been voted on by the Illinois House. And if we had what Arkansas had, binding referendum, we would have raised the minimum wage back in 2014. And voters are voting on that in other states this year. So sometimes that's the only way to get around big money, is to do it with shoe leather and everyday people. So it's frankly sad to see some of the things that have gone on. I really feel Illinois is on 4 flat tires. And, when you're in office, when you're governor, you got to tell the truth. Tell it straight to the voters. Sometimes it's tough medicine. And there are those in politics who want to tell people what they want to hear rather than what they need to know. And I had to tell the people of Illinois in the election of 2010, we needed more revenue to pay the bills, to pay the pensions, to make sure we had schools and hospitals and public safety. I won that election. It was close, but I won in a Tea Party year. But I didn't win in 2014. So I'm never going to deviate from the message that it's much better to tell people the truth. And for those who don't, they end up with a $15 billion deficit, and they have to figure out how to get out of it.
Thank you. Okay, then a follow-up from Graham and from Jane. Pat, you have been seen in the company of a 33-year-old regularly. How is Betsy? And Jane wants to know if there are wedding bells in your future. Do you have a big announcement to make today?
Well, Betsy is the nickname that my assistant, Lou Bertuca, gave to my briefcase. That it's 33 years old. All right, soon to be 34. I got it on my birthday in 1982. It survived a lot. I've gone to Iraq. I've gone to Afghanistan. I've been all over. But Betsy is still there. Now, it wasn't dire straits. I went to a shoemaker, Tony's Shoe Clinic, and somehow he rescued it and put it back together again. So it's alive and well, and I'm sure I'll be married to it for the rest of my life.
Pretty good answer, huh?
Next from Springfield, State Senators Andy Manar and Sam McCann hold a press conference to discuss legislation they're supporting that would prohibit executive branch appointees from participating in or influencing elections. This runs about 15 minutes.
Today in the Capitol building, Senator McCann and I are here today to talk about legislation that we're filing this afternoon to strengthen our state's ethics laws specific to the conduct of executive branch appointees. This is a straightforward piece of legislation, again, that we're going to file this afternoon that will close what I would describe as a gaping hole that exists today in our State Ethics Act. Simply put, our legislation would prohibit executive branch appointees from participating in or influencing political campaigns. I'm of the opinion that agency directors should not spend their time campaigning. They should spend their time managing the agencies that they have been entrusted to run and to manage when the Senate confirmed their appointments. I want everybody to think about this for a moment. Our State Ethics Act today allows for executive branch appointees who are trusted with the authority to license and to regulate, executive branch appointees who control billions of dollars of grant funds or funding in general, to campaign for or against candidates for the General Assembly or any other public office in the state today. I think that's wrong, and it should stop. Today, the federal government has these standards in place, the ones that we are seeking in the bill that we're filing today. And those standards have been in place for years on the federal level. And we've done a little bit of research. We haven't gotten through all 49 other states. But every state so far that we have looked into has similar provisions that we are seeking in this legislation that, again, would prohibit executive branch appointees from participating in elections and influencing the outcomes of elections. And quite honestly, I'm surprised that we haven't done this years ago. We've taken some pretty good steps forward since the days of George Ryan and Rod Blagojevich to strengthen ethics laws in Illinois. We should always find ways, especially in a bipartisan way, to come up with ways we can raise those standards. That's what we should always seek to do. Senator McCann and I think we found a way that we should move forward to, again, raise the bar of ethics in Illinois. Senator McCann.
Thank you, Senator. I appreciate it. And Jordan, I was actually standing right behind Jordan. You couldn't see it when all this went down, and I'm so glad with the great target area that the bird had that he chose you, my dear. I'm sorry you had to take one for the team, as Bernie put it, but it was interesting. So thank you for joining us here today. Again, I'll echo Senator Manar's comments. I mean, this is good government. This is what we should do, regardless of who's in control. Too many times I hear it said in the halls of this building. I hear people from both parties talking in the hallways about, well, that's what they did to us when we were in control, and now that's what we're going to do to them. And I hear that both ways, and that has to stop. And this is one place that it can stop. We've done a lot in recent years to provide better government. This is another step in the right direction. This isn't a panacea. It's not the end game, but it's a good start. And so it's good government. It's fair. It's unbiased. It's what the people deserve. Once you're appointed, if you're working for the people of Illinois at that level, that it requires a governor's appointment and confirmation by the Senate, you need to be doing your job. You shouldn't be electioneering. So with that, thank you for being here. Thank you to Senator Manar and staff. And I guess at this point we'll take questions.
Why now? Well, I would argue, Dan, this should have happened years ago. You know, again, I was surprised, and, you know, I talked to Senator McCann about this a few weeks ago, and we wanted to make sure that, you know, we were right about the Ethics Act, and come to find out, this is a gaping hole in our Ethics Act where we can make a very significant improvement. And, you know, no one's taking part in wrongdoing today because the law allows for what's happening. And this is a bipartisan issue. This has happened in the past under Democratic administrations. It's happening right now under a Republican administration. So we're of opposite parties, and we're here today to say that we think this is a good government approach to strengthening ethics in the state. So you know, I think now is a good time to have this discussion. That's why we're filing a bill today.
What is going on? Who's campaigning for who? What have you heard?
So, you know, you can look at races in the vicinity of Springfield, for example, where the director of the Department of Natural Resources is out campaigning for a candidate for the House of Representatives.
Is that Jimenez? Or?
No, it's for Representative Bourne. Okay. You know, and I don't want to put my colleague on the spot, but that happened in his primary as well. And rewind the clock, Bernie. I don't want to pick on just a couple of races. I think this is quite common. If we spent time and we actually looked at agency directors that had a hand in campaigning over the years, I think it's more common than what most people think. It's prevalent today because we have competitive races here in the Springfield area. And I think back to the previous question, now's the time I think we should talk about this and we should deal with it. I'm not here to point fingers, but I am here to say that, you know, when Director Rosenthal, for example, then Representative Rosenthal, came before the Senate Executive Appointments Committee, I was proud to sit right next to him. I was there to support his appointment as Director of the Department of Natural Resources, despite the fact that many of my constituents were angry that he just took an oath to represent the 95th District in the House of Representatives and turned around and took an appointment just a few weeks after that. But nonetheless, he was qualified to do the job. He's a pretty stand-up guy. But when I sat there next to him, I think my expectation was at the time that he was going to spend his time managing the Department of Natural Resources, not campaigning. So I would apply that standard to any Democratic appointment too. So this isn't only applicable to one party or the other. This is just something that makes a whole lot of sense, that's been in place for years on the federal level, that most states have in place today, that will raise ethical standards in Illinois.
Well, I would like to speak, to kind of combine the questions, to speak to you said, why now? Well, if not now, when, right? So it's never too late to do the right thing. It should have been done a long time ago. When Senator Manar and I started talking about this issue, we were both surprised that there wasn't something on the books at least pertaining to it. So if not now, when? Now is the right time. Also, I think it's important to point out, we're not precluding anyone from participating in the process as citizens. They can still take part in the process if they have someone they want to support, if they want to go to a fundraising event as a citizen and write a personal check. They can still do that. We're not precluding them. We're not revoking any of their rights as a citizen in the the electoral process. So I think that's important too. Again, it's just, I think, drawing a line, just like you. Where is the line? Well, I think I outlined that earlier when I said I think if it's a gubernatorial appointment, if it's an executive level appointment that requires the advice and consent of the Senate, that's the line.
Well, this says political management is okay. What does that mean? Can you manage a campaign?
So it's going to be modeled off the federal law. The federal law simply says that agency appointees, executive branch appointees, and there's a few nuances, but generally it's confirmed by the Senate, cannot participate in paid political communications. So as Senator McCann said, if somebody wants to contribute personally to a campaign, that's one thing, but using their capacity as an executive officer in government and then translating that into a campaign, that's a whole nother conversation that today in Illinois is completely legal. We're saying it shouldn't be, because as evidenced by what the federal government's done and by what most other states do, that's a line, as Senator McCann said, that should not be crossed, because we have appointees who by their appointment, it should be noted, have doubled their salary, have received significant pension enhancements because of that appointment, and then they're turning around and supporting candidates. In this particular case, and again, this applies equally to Democrats and Republicans, but in one particular case is supporting candidates that the governor supports or opposing candidates that Governor Rauner opposes. So again, I don't want to focus on those specific examples, because this, if we get this in place, it's going to be, for all administrations in the future, Republican and Democrat. So we just think we should align our laws with other states and with the federal government, and it wouldn't preclude an individual from supporting a candidate, voting for a candidate, writing a personal check, going to a fundraiser, but it would prohibit an agency director from participating in a paid political communication, which again, I think is more common than most realize.
The director Rosenthal cut an ad for more TV?
Radio.
Radio, someone's already playing?
Yeah, mail, yeah.
So you're saying a person can, a director or whoever, who was an appointee, could still go to these things.
Sure.
But they couldn't do TV, paper, radio ad. Is
paid communication? Yep, that's the line.
Okay. Well, my question then is, I just playing devil's advocate. Let's say a representative, Senate member, whoever, gets an endorsement from an IEA or any sort of agency or union group, whatever, that kind of does benefit from the state. Would they be under the same microscope then?
No.
No. Would that agency be under the same microscope, to say? Because I mean,
well, what agency? I mean, is it a governmental agency or is it?
I'm speaking in generics. Like, let's say it's an ASME group or an education group, whoever, who makes these contributions to or pays for these ads.
Well, but they're not governmental agencies, right, where they don't get appointed by the governor.
No.
But they don't.
They get government contracts.
Yeah.
So they would benefit from the state. I'm saying.
Again, you asked us about the line, and the line is if they're appointed by the executive branch and confirmed by the Senate, then there's the line. There's the line. And it's a reason, and as Senator Manar has pointed out, This has existed at the federal level for quite some time, as it exists in many other states.
But is that fair, though?
Well, I think, so may I ask, do you think what's currently going on is fair? Is that?
I think the entire system that's going on, from A to Z.
And that's why we're here, and that's why we're here. That's why I said, why now? Why not now? When else? And this is a step in the right direction.
I mean, you're doing this because the people who are in these positions, it would seem like a benefit to the people who are being spoken on behalf of or whatever by these directors, whatever. Oh, wouldn't that be the same thing if the IEA?
No, this is why. Because taxpayers aren't paying the head of the IEA, number one. The head of the IEA is not confirmed by the Senate. It's confirmed by the members, the thousands, hundreds of thousands of members of the IEA. When taxpayers employ the director of the Department of Natural Resources, I think taxpayers expect that director to run the department, period. Period. What about what?
What about after hours?
Well, sure. That's different. But the bill prohibits paid political communication with those individuals participating in that.
They can't use their name. They can't use their
face,
position.
their position.
Right?
Yeah.
What does apply to constitutional officers?
That's a good question, Monique. We'll get you a. We're going to file the bill today. Let me just look real quick. No, because it's no. Yeah. No. So we define. I'm sorry. We define affected employee as any director, secretary, assistant director, assistant secretary, deputy director, or deputy secretary of any agency or department of state government created by statute who is appointed by the governor and whose appointment requires the advice and consent of the state senate.
And is the difference there because it's an employee appointment and not an elected office?
Absolutely. Because elected individuals are accountable to voters through elections. Appointees are accountable to the governor as the appointing authority through the check and balance of the Senate. So again, when Director Rosenthal came before the Senate, and I was proud to sit next to him to support his appointment, because clearly he's a qualified appointee. That's what I said to the Senate Executive Committee, Appointments Committee, excuse me. And when I did that, it was with the expectation, like with every appointee for every agency, that they're going to spend their time managing their respective agencies. I think that's what most taxpayers expect. And when they venture off into politics, that, by the way, would not be allowed by the federal government, and it would not be allowed by other states.
I imagine we might hear some agency directors who say I am capable of doing my
Of course.
job and doing this separately.
Of course.
And we're by no means calling into question their capabilities, their qualifications to do their job. That's not at all what this is about. It's simply saying there's a line, just as we have established line. You know, at one time, from what I've heard from other people in this building, and some of you have been around here a lot longer than I have, you used to be able to do a lot of things here that you're not able to do today. And that's because of various attempts over the years to make the standards better and stronger. And that's all this is. It's establishing the boundary.
Next, from Chicago, we sit down with Christopher Hurley, the president of the Illinois Trial Lawyers Association, and talk about the types of cases a trial lawyer would take, why he says class action lawsuits are necessary, and the effect of workers' compensation on Illinois job growth. This runs about 50 minutes.
Chris Hurley, thanks for joining us on the Illinois Channel. You are currently this year the president of the Illinois Trial Lawyers Association, and with a number of issues being discussed by candidates and the governor, we thought we'd want to get together with you and kind of get your thoughts and the thoughts of the Trial Lawyers Association on some of these particular issues. Before we get into them specifically, tell for those who don't know, A, what are the trial lawyers? How does a trial lawyer differ from some other type of lawyer? And let's just start there.
Okay. Well, as a trial lawyer, I'm a person that represents usually individuals or human beings that are injured in some way or have in some way been harmed either by another person or a corporation. And it can be all kinds of different things. I mean, it can be car accidents or medical negligence or product liability or construction accidents. but it can also be business disputes and that kind of thing. So as a trial lawyer, I'm the guy that can go into court and make an argument for my client, and in my particular case, and for most of us, we represent people and not corporations.
And I guess the difference is a number of lawyers, depending upon their practice, might not ever go to argue a case in court.
That's actually true. It's a very small number of lawyers as a percentage that actually go in and try cases in court. You know, it's not a skill everyone has, and it's not you know, the type of work everybody enjoys. I happen to love it, and I think most of our members love this kind of work, and that's why we do it.
Does it take a particular kind of personality, or do you find that your comrades, their personalities just run the gamut?
Yeah, like anything, you can't overgeneralize, but it has to be somebody who is up for a good fight and doesn't back off. You know, when somebody needs a champion in court. So you have to have the guts to go in there and make arguments, and you have to have the willingness to take risks. And sometimes you win, and sometimes you lose, and you have to have the courage to face that.
How? Again, we'll get into the issues, but I'm just still kind of curious. And I guess people would, you know, in a negative sense, when people often say, well, you know, I'll sue or this, that, and the other, your association or your branch of the law, you might say, that those lawyers who go into court are the people that will take someone's case and say, we're suing someone, or, you know, for, as you mentioned earlier, something that allegedly went wrong. Some mistake there, some injury, either physical or some other fashion, business injury, something that should not have happened in the way you would argue it.
Yeah, we're the guys that give the average person the ability to get his rights brought to court and decided, you know, according to the rules of due process by a judge and a jury. We're the guys that enable you to do that. You know, I worry sometimes because there's, you know, comedians or whatever make comments about suing and, you know, everybody's sue happy. I find that to be not anywhere near the reality that I live. We don't bring frivolous lawsuits. We only bring lawsuits that have merit, and there's a reason for that. Juries don't award money in frivolous cases, so I can't make a living representing people that don't deserve to be in court. So we're very careful to only bring cases that have merit, and that have merit both factually and legally.
Let me bring up what sometimes here and there we'll bring up what some of your critics would say. Now, critics might say, we would accept that you're not going to bring a case to court that doesn't have merit, but that, and I don't mean you as an individual, but that trial lawyers, they would say, often bring cases hoping that the person that they're threatening to sue will just settle and they can make a quick $10,000 or $20,000.
Yeah, that's not been my experience. So I've been doing this for 35 years, and it's not been my experience that you can get away with that. You know, look, if the case shouldn't settle, then it doesn't have to settle, and you can...
Isn't there a cost factor, though? I mean, I know a case where there was a bus hit a car on a snowy day when the car was... So, you know, who do we blame? Mother Nature? But someone who was on the bus said they were injured, and the insurance company for the car owner just paid them off, you know, like $10,000. It's you know, you hear some of these things where we've heard stories where on another case involving a bus where there were more victims than there were bus riders.
Yeah, these are anecdotal stories, and often you have to be careful of the source when you hear those stories. So make sure, first of all, you find out who's spreading that story. There's one that circulates on the internet. It's called the Stella Awards. Every year, have you ever seen this? Where I get this from my friends, or you know, friends who are not lawyers all the time. They send me this internet piece where they report 10 incidents of crazy things, like a guy put his cat in the microwave and then sued the microwave company and got $1 million. Okay, obviously would be very upsetting if it was true. It's not true. So when you hear these anecdotal stories about people that got jackpot justice, first of all, consider the source, and second of all, find out if it's really true.
Well, sometimes it would be true, though, right? I mean, and we wouldn't say, let's say not $1 million settlement, but you get these where people will, you know, okay, look, some corporation's going to pay. There was a Wall Street Journal article some years ago. A guy pulls over because they were taking the American flag down, and it was a big flag and kind of a windy day, and he held on to just be helpful. A gust of wind catches the flag, picks him up, and hurts his back. And a flag maker was named in the suit. He said, it wasn't even my flag. And they settled for $6,000. He said, if we'd gone to court, it would have cost you at least 10. So,
yeah, you know, I'll tell you.
As an association, again, I want to make sure people understand I'm not targeting you as an individual, but as a spokesman, to what extent when we hear these, are they true? I mean, certainly there's some exaggerations, but are there problems along these lines that need to be cleaned up? Are there charlatans in the industry, whether or not they're members of your association? And if there are, is there any policing mechanism to try to say, you know, when someone brings a suit, it's going to be for legitimate reasons, as you would represent. Here's a client that's been injured in one form or another.
Sure. So there's good lawyers and there's bad lawyers. There's good doctors and bad doctors. There's good journalists and reporters, and there's bad ones, right? So that's true of every profession, and right. We do in the legal profession have a mechanism called the ARDC, where if the public feels that it's been treated unfairly or wrongly by a lawyer, it can be reported, and it is investigated in every single case, and it's thoroughly investigated. And if there's any merit to it, the ARDC will censure and punish the lawyer, and in some cases take away their license. So that happens on a regular basis. And it's unfortunate that those lawyers are out there, but we have a mechanism in place to police them. Now here's the second thing, though. Each case that's brought, is going to have a judge, and ultimately, if a jury is requested, will be decided by a jury. If the case is as frivolous as you say, and this flag case sounds very suspicious to me, so I can't even imagine filing a case against a flag manufacturer for those facts. But if somebody did that, there should be a judge who sits in that courtroom, and there's a procedure called summary judgment, where the defendant can bring a motion for summary judgment and say, Judge, I can't be sued for making a flag in these circumstances. And the judge in that case should throw that out. And there should not be a payment. And if some insurance company makes a business decision about paying frivolous suits, well then shame on them. Don't pay frivolous suits. I don't believe in it. I don't file them. I don't think they should be paid. I don't think they should be brought. And most of the insurance companies I'm familiar with, the smart ones, don't pay on them, and they shouldn't.
Let's go to some of the issues that have been brought up. Governor Rauner has argued a number of things in an effort to turn around the state economy, and among those would be that he wants to get workers' compensation down. We just interviewed the head of the Illinois Manufacturers Association, Greg Bays, and one of his members. And they say that, the cost of an injury to an arm, that they're not trying to take away benefits from a worker, but that the cost of an injury to an arm in Illinois would be 50% more than it might be in a neighboring state. Now, maybe that's the fault of the medical society, I don't know. But the other thing, of course, is this issue of causation. And that if somebody is injured outside of work, but maybe some small percentage of the contributing factor was work-related, that the owner of the business, his workers' comp insurance, will have to pay for the entirety of the bill. And they're saying, if someone sprains their ankle playing softball on the weekend, and then later when they're carrying a box of books or something, the ankle gives way at the work site, we shouldn't have to pay for the whole cost of that because they were injured off the job predominantly. What say you about causation?
Well, you know, you can't throw out a worker's case because he has a pre-existing condition which may have made him susceptible to an injury. And so, you know, certainly there should be no cases where fraudulent claims are paid. And again, there's a procedure in place. There's a mediator, an arbitrator that is independent, who's required to make the decision and make sure there is causation related to the work. And those people should never, you know, obviously if there's fraud, that should never be paid. And no one in our organization would ever want something like that.
Should there be a situation where, well, how is it now, just to make clear? Is it true that the business then would have to pay for the entire cost of that injury? And let's say, again, maybe I'm making something up, but you know, maybe he injured his back playing softball, but then when he's moving furniture in his office, he throws his back out again. Well, to what extent does the business, first of all, the way it currently exists, does the business have to pay for all that?
Well, I mean, to the extent that the business and the work that they are having the worker do contributed to an injury, they should pay for it. Because what's the alternative going to be? You know, this is a guy who might have a white...
Can I interject for a minute? But because when you say they should pay for it, I think the question then is, do they pay 100%, or should they say, well, he injured his back, we knew he was injured his back playing softball, maybe he took a day off or 2 days off because his back was bad after the weekend? Should they have to pay 100% then? Or I think that's part of the argument of some of the, not just manufacturers, but business community, that they're saying, you know, maybe we do 30%, but we're picking up the whole thing, and it really had nothing to do with our work environment or how well we managed the shop floor or how we had things marked on the floor and trying to be careful.
This is really an insidious argument by the Manufacturers Association and,
businesses at large,
and whoever's making this argument. Because here's the thing with the workers' comp system: it's a compromise system, and what that means is that if I lose my leg on the job, okay, if I'm a $15 an hour worker and my leg is lost due to your gross negligence as an employer, okay, I recover about, you know, if I'm a $15 an hour employee, less than $100,000 for that injury, for the loss of my leg, okay? Now, that's a reduction in what that person could earn if they were able to go to court in the civil justice system and sue the employer for negligence, where I think a jury would easily award millions of dollars for an injury like that. So the employers are getting something for a system where the employee is guaranteed some recovery, okay? So rather than having to prove the negligence of the employer when an employee loses his leg, he gets an automatic payment of his medical bills, a portion of his lost wages, and some small payment for the permanent injury that he suffered. The employer, in trade-off for getting the reduced payment for this obviously horrendous injury, has to pay any time it happens at work. And so now employers are saying, well, we don't want to have to pay if some of it happened outside of the job.
But is that a legitimate argument to say if part of it happened outside of the job, why are we responsible for 100%?
Okay, well then fine. If they want to go back to a system where then the employee has to prove, you know, what percentage happened on the job and off the job, perhaps the system should allow the employee to get more damages.
Do other states have such a system, or systems different than ours?
I'm not sure what all the different states do, but I can tell you that in our state, in the last 5 years, since reforms were pushed through in 2011, our costs are down and our rates should be coming down, but they aren't coming down because the insurance companies aren't lowering the premiums.
I was going to say, I think there was a study out of Utah about a year ago, and if I remember right, Illinois was approximate, in the top 10 or so of, from they listed all the states as far as the cost of workers' comp. I don't remember precisely. Let's just say Illinois was very near the top, in the top 10. The governor's saying, you know, if we can make some reforms, and Greg Bays with the manufacturers say, we don't have to go down to compete with Indiana, which is almost at the bottom as far as the cost. But can we get to be where we're around 23, 25 of the states instead of, say, you know, 9 or 10 as far as the cost? Because that puts us at such a competitive disadvantage. From the Trial Lawyers Association, have you entertained the idea of what reforms, if any, could be made or should be made from your perspective to bring that cost down?
I think the reforms that should be talked about would be insurance reforms. So, you know, why do we have hundreds of companies that come to this state that want to write workers' compensation insurance? Are they doing that because they're not making money? I mean, there literally are hundreds of companies that write this insurance and are charging manufacturers and other employers for this insurance. Why are their premiums not coming down when we know costs have come down since 2011? So if we want to talk about reforms, let's talk about insurance reforms.
I started to ask, why do you say costs came down? The costs from the previous reform effort, you were saying, broad costs.
In 2011, an insurance or a workers' comp reform package was pushed through, which has resulted in our state being one of the better states in terms of decreasing costs for workers' compensation. And so, you know, and now they want more.
Well, when you say one of the better states as far as bringing the cost down, and but earlier you were mentioning that the costs really haven't come down much. You were blaming the insurance company for keeping it high. What costs have come down from, I mean,
sure.
How do you measure that?
The National Council on Compensation Insurance advises that Illinois rates should be cut by 13%, and they have not been cut. Medical payments.
And who is that group? Is that a
National Council on Compensation Insurance?
Okay, is that an insurance industry group?
I think it's an insurance. I'm not sure who it is, but I know it's a group that puts out information on insurance rates, and they've advised that the rates should be cut. We know medical payments are down 15% in our state since 2011. We know the average medical payment in Illinois is $14,000, while the average medical payment in Indiana is $18,000, Wisconsin $17,000, and Iowa $16,000. So there's been a 19% decrease in workers' comp benefits paid out since 2011. So, you know, the industry just wants more, and they haven't really shown us why they should get it, number one. And number two, any discussion of reform needs to start with insurance reform.
Have you, as an association, I mean, typically the trial lawyers are a big supporter of the Democratic Party, Speaker Madigan. Have you reached out as an association to the governor's office and said, you know, let's sit down and given your views as to what should be done, and said, hey, take a look there at the insurance companies, because maybe that's where the problem lies?
So the governor, when he was running for election, held up a list of all the judges up for retention and just said vote no for every single one of them without regard to any of their qualifications or abilities. Just because I guess it's his view that the legal system doesn't work. It's quite clear that the governor doesn't want to have a dialogue with the trial lawyers. And, you know, I'm sure I could call him, and I'm sure my call would go unanswered. But, you know...
Because have you as an association reached out or made the effort?
We are always available to talk to the governor. And, you know, if he wants to talk, I'll be there the next day to talk. But it's clear to us that he's already established in his mind what his agenda is, and his agenda is to make it cheaper to injure workers in Illinois by reducing the cost.
I think he would say that he wants to make it cheaper to insure the workers, right? I mean, to have just the cost of insurance come down, yeah. Which, whether it's, if it's, as you say, the insurance companies that need to just lower their rates based upon the level of incidence, Have you
Well, wait,
looked,
hang on, let's go back to that. When the governor's agenda is to make it less expensive for companies to have workers' compensation, that means it's going to be cheaper to have injured workers in Illinois. And here's what you'll get with that. You'll get more injured workers. That's his agenda. So be careful what you wish for. No, I'm sorry, go ahead.
I'm not going to argue. I mean, I'll try. I'm not arguing for him, but I would say I try to represent what I think the other side would say, so we can get your response, and we got that. The business owner we just said would say, look, it takes us. It's a long, hard task to get right the good workers. It's to find good people, and you want them to be productive. You don't want them to be injured. So no one wants someone to be injured. Aside from just the humanity of it, they would say it makes us less efficient if we're going through 12 to 20 people trying to find the one we're going to hire. When we find that person, we don't want them to be injured on the job. That's, you know, and that they're saying we're trying to do our bit to keep the workplace safe, but we just want to
Well, you know,
not have our costs continue to increase.
Well, yeah, sure, but talk's, you know, cheap, Terry. It's really what you do when it happens. You know, when I say be careful what you wish for, I mean that sincerely. And I just, if it's okay, I'd like to go a little bit back in history just to remember how we got to where we are today. If you remember, I'm sure many of the viewers will remember the Triangle Shirtwaist Factory fire in New York back in 1911. Okay, this was
all the children were.
Yeah, this was a case where young
kind
girls,
of a sweatshop in New York City.
young girls were in a sweatshop on a 10th floor of a building in a factory, and the owner of the factory would lock the exits because he was afraid they would take unauthorized breaks, and he was afraid that they'd steal things on the way out, some buttons or whatever, so he'd lock them in. And so a fire breaks out on the 10th floor of this building, and the owner gets away, and the foreman escapes, but 146 young ladies died in the fire. Some of them, about a third of them, from having to jump out of the building. And so what?
It's some extreme. I mean,
well, no, but hang on.
You wouldn't argue that that's the case today. That workers or employers, generally speaking, are doing that kind of action.
You know, the argument that workers get too much when they're fairly compensated from an injury at the job has to keep in mind the system we came from, which is a system where it was totally slanted in favor of employers. And so where in that case, the Triangle Shirt case, the employer, upon being found guilty for wrongful death, only had to pay $75 per death in that case. And the insurance company paid him $400 per death because he lost time from work. So there's a situation we don't want to go back to. We want workers.
But no one's arguing that. No one's arguing that we go back.
No.
That we set the clock back entirely. And I want to move on to some other issues, but I think they were just saying we don't mind having a system. We don't mind having workers who get injured on the job being compensated and taken care of. We mind that in Illinois the cost is so high relative to other states for whatever reasons. And maybe they're pointing erroneously at the trial lawyers. I mean, you would argue it's not yours, it's the insurance. But I think as far as where employer groups would say is, we're trying to compete with the guys in Iowa, and Indiana, and St. Louis, Missouri, and et cetera, Kentucky, and all of those places. One, the cost is lower, and B, as a manufacturer, let's say, I have a fiduciary responsibility if it's a corporate-owned place instead of a sole proprietorship. I have a fiduciary responsibility, and if I can move 1,000 workers to a different state and save $1 million a year in workers' comp, I'm going to do that. In 10 years, it's $10 million, and that's so. The governor and others, I think that's the contention that they're saying. It's the cost structure of the insurance, not have insurance.
Look, it's a continuum, right? And
right.
You know, your point's right. Nobody wants to go back to the turn of the century when life was cheap. And workers could be injured with impunity, and there'd be no consequence. We don't want to go back to that.
Right.
And we don't want a state where, you know, companies can't afford to work. But we do want a state where workers are treated with dignity and respect, and they have the right to work in a place that's safe, and it's not cheap to injure them. That's what we really want. So that falls in between, and I'd agree with you on that.
Let's, we'll move off, but just to close out on this, it's one of the major issues, so we want to spend some time on it. And we do hear the governor speaking a lot, so we appreciate you coming in to give the other side of the argument from your perspective. Of cases, whether your own, let's not just take your own, because any lawyer could have a different structure. What % of trial attorneys' cases, I don't know if you know this or not, are workers' comps? Is that a big part of the industry? Is it a minor part of the industry? How does it rate?
Well, in my particular case, we don't do much of it. We refer it out to other lawyers. There are, I think it's
probably some people specialize perhaps in it, or some. Or
there are definitely firms that specialize in it. As a percentage of our organization, for example, I think it's a fairly small percentage. It's probably 10%.
With trial lawyers, and let's just say, if we had a pie chart of all the different kinds of cases. And again, I'm thinking more of an industry because any lawyer might specialize in certain cases. What kind of things are there out there? What would be some of the big items within the industry where suits are being brought in this economy?
Well, it's I don't know of any studies.
I mean, is it a lot of medical? Is it I don't know. Do you take cases of fraud? I mean, we just look at this Wells Fargo case here. They had a golden reputation. It turns out they were defrauding. I don't know how many people.
Classic, yeah.
And that would almost be a class action lawsuit, would it not?
Yeah, potentially, I would think it would be. I mean, so it's a perfect scenario for a class action. So let's just
and
tell
let's
everybody.
Explain why that would be.
Yeah. So the Wells Fargo case, as I understand it, and I'm not a banker, but as I understand it, there were salespeople in the bank creating accounts for clients of the bank without their permission. So you're going along and everything's fine, and you're getting billed for accounts that you didn't want and you don't need. And it's probably a small amount per person. Let's say they charge you $20 a month for this account. Some people might not even notice that until some time went by. The point is, when you do notice it, you're like, hey, I paid an extra $100 for accounts I don't need, and you call Wells Fargo. And it doesn't have to be just Wells Fargo. It could be any big corporation, your cable company. You call them up and you say, hey, I want my $100 back, and they put you on hold and they don't come back, right? So what's your choice then? You can then call the attorney.
Because the average person is not going to go to court over a $20 a month bill or something.
Exactly. So you have a $100, $100 has been stolen from you. Now you call the Attorney General, and maybe if it's a big case like Wells Fargo, the Attorney General gets involved and they've sanctioned Wells Fargo. But if it's something less than that, the Attorney General might be too busy, so you get no help there. So then you call up a lawyer, and the lawyer says, well, okay, that's great. I'll take the case. I charge $250 an hour. And the client's like, well, I lost $100. So there's nowhere to go there. So the only thing the law provides in a case like that is a class action mechanism. And that's where hundreds or even thousands of people can join together, and it makes it a big enough piece of litigation that you can afford to pay the lawyers, and it makes sense to bring it that way. And so without that, there's nothing to stop a company of that size from doing really what they want.
I'll tell a personal story. You just reminded me. I got a postcard in the mail, and I almost threw it away thinking it was some phony baloney scheme. But I had an earlier version of an apple and a little bit of liquid in my pocket from a mouthwash container leaked into this phone. And Apple would say, well, we don't guarantee it if the phone had any kind of liquid. Unbeknownst to me, there was a class action lawsuit brought. And I got $250 back from the
Oh, is that right? Yeah.
So I mean,
but I mean,
I thought it was unfair. So I mean, there's a case where, and there was an argument made. Again, I'm not arguing the governor's case. I guess I'm representing their case. I'll represent in this case perhaps the trial attorneys. To some extent, we had a panel discussion, which I believe I mentioned to you off camera before, but here at the Union League Club of Chicago. Are class action lawsuits a good thing or a bad thing? And one of the points made by those arguing for the class action were that there are not enough regulators in the government, nor do you want to have, with the salaries, the pension benefits, the cost of having someone always on duty as a regulator.
Right.
You don't want to have people constantly looking over your shoulder. But there's not enough regulators to keep people honest, and so we have things that come out. Wells Fargo here, we'll let them argue their own case, but I mean that's the kind of thing that can happen, and that the argument was that trial attorneys as an industry, you might say, are the hired legal guns, that if someone takes advantage of people in some form or fashion, that you're the ones that would go to court to represent them and keep the system honest.
Yeah.
Is that more or less the case to be made for the industry?
You couldn't have said it better than I could have. I mean, it is the only thing that stands between us and really the domination of our legal system and society by people with money. So, people that don't have as much money need access to the courthouse, and we need to be able to police these corporations and moneyed interests. Now, sometimes it's just some corporate people that have run amok, and sometimes it's what's the Volkswagen case, right, where they deliberately falsified the air quality.
They didn't want their cars were not complying with the EPA standards, so they falsified the reports to say that the cars were matching the EPA standards.
And so it's the instant that comes
and
out.
And again, another major corporation with a good name.
Right. And the instant that comes out, the value of the car you bought plummets, right? Because everybody knows it's a fraud. And so if lawyers can't get involved to bring a corporation like that to heel, the rest of us have no chance.
We have right now, as we sit here, the Samsung case with their phones, their batteries. Now that would be a case, I would guess, I'm going to presume, because it doesn't seem like it would have been in their interest to have put out phones that they knew were going to be catching fire and exploding, etc. On the other hand, there's going to be some people who are injured.
Right.
Who are going to, their leg is burned, or maybe their house burnt down, their car burns down. There's one example where a car caught fire because of the phone. So what's the real answer in a situation like that? I mean, in other words, if you have, in this case, a manufacturer who wasn't purposely trying to put out a bad product, but the product was, on the other hand, bad. It was faulty, and it did cause some damage. What's the response of the industry to something like that?
Well, I think the immediate response is recall the dangerous product. And what you'll see them do sometimes is they wait to recall it. And that's really where the problem comes in. So we've seen that with the General Motors cases where the car would get stuck in drive and you couldn't get it out of drive and people were being killed, and they delayed the recall. Or the Ford, the most, an interesting example is the Ford Pinto case. You remember that case? This is back when Ford knew that with a relatively small rear-end impact, the Pinto would burst into
flames, yeah, because the gas tank would explode, and that, I figured it was maybe a $50, maybe not even that much cost. But
so they recognized that was happening, and they recognized that they should recall it, but they also recognized that it was cheaper to pay the wrongful death claims than it was to recall the products. And that's where the problem comes in. As soon as they discover the safety problem, they need to recall it immediately. Now, I don't know how long Samsung has known that their phones burst on fire, but presumably the second they found that out, they need to recall all of those. If they don't and people are injured because they made a calculation that it's cheaper to pay the claims than it is to recall the phones, then that's the kind of thing a trial lawyer needs to show to the world and make an example of them on.
You know, one of the it's funny, we just talked about Samsung, we talked about Wells Fargo, we talked about Volkswagen, you mentioned Ford. There are these instances, and we don't want to say all corporations are bad. As you say, sometimes it might be a lower middle management guy who's trying to cut costs to make himself look good. You never know where the costs. I don't want to leave people with the impression that corporations are out to take advantage purposely. Sometimes I think, like in the Samsung, I will presume that it was a faulty design and they just weren't aware that these batteries were as bad. One of the big cases that came out not too long ago, and it was in St. Louis, I think maybe a year or 2 years ago, a woman had been using talcum powder by Johnson & Johnson, another great name, great corporation, been around for over 100 years. And a lot of people have used it. I guess it's the equivalent of baby powder is what I would imagine.
I believe that's what it is, yeah.
And so all kinds of people have used it and used it for years. Now, her family, because she died of cancer, are saying it was caused by the talcum, and I think they got a $72 million judgment, if I remember. And we see the commercials from that. This is where I think some people look at that and they think, trial attorneys across America smell blood in the water. And so now we're running the ads and bring us your cases because we've got this. What would you say to those people that make that kind of a statement?
Well, I mean, so if the statement is that trial lawyers are bad because they want to help people get justice, I honestly don't understand how I can respond to that. I mean, here's the thing. If Johnson & Johnson knew, and I don't know, I don't have any of those cases currently, but if Johnson & Johnson knew that its product was causing cancer in consumers and chose to sell it anyway, why does it matter if a lawyer might get paid by bringing a case like that? That kind of conduct cannot be allowed to stand. Those people, if they knew, I mean, it's like the asbestos industry knew since the 1940s that asbestos caused mesothelioma and other serious, awful cancers. And they chose to sell it anyway because it made them, it helped them reach their corporate goals and their money goals. That cannot be allowed. And to suggest that because a lawyer who spends his career and many hundreds of hours working to fight for justice for those people also gets paid, that for some reason is that's somehow a reason that the case doesn't have merit, that doesn't make sense to me.
Let's speaking of asbestos cases, one of the arguments made by groups, and we recently interviewed, I think, or not interviewed, but aired comments again made here at the Union League Club from the Illinois Civil Justice League, that the case of venue shopping, that the lawyers are gaming the system by bringing cases, filing cases in venues where they know they're going to have a sympathetic audience as compared to maybe the specific incident of where it happened. And so they often cite Madison County, Illinois, where a great preponderance, their argument is, of cases, and I don't remember what the number they use, of asbestos are brought. On the issue of venue shopping,
it's another interesting question. So you have a judge who's responsible for making sure that venue is proper in our state when somebody brings a lawsuit. And venue is proper if the corporation has an office or does business, or is a corporation that has a headquarters in our state. So that judge it's fairly simple for the judge to screen for that. If venue is proper under our laws, then there's another way the court can dismiss the case and send it elsewhere. It's called forum nonconveniens, and that requires the defendant to bring a motion saying, hey, this is not a convenient place for this case to be because all the witnesses are in Louisiana. Okay? If the defendant doesn't make that motion because the defendant would rather have it in Illinois, then who's complaining?
Why are so many cases heard? I'm presuming that that statement is accurate. Why are so many cases heard in Madison County?
Well, I think it has to do with the fact that some of the lawyers that are specializing in that practice have offices there. It probably also has to do with the fact that the defendants don't want to have to travel across the whole country to litigate all of their cases. Now, let's say you're a corporation that has 300 cases against you that involve asbestos injuries. You may not want to go to 50 different states to try those. You may prefer to have them all in one place. But to then go and say the system's broken because both sides want to be in Madison County doesn't make sense to me.
When we have a case, and I think with the talcum powder, there's now a settlement fund set up. How does that work? I mean, here typically you would be arguing, trying to win your case, and if you get it, you get a settlement. But when a settlement fund is set up from some, whether it's asbestos or the talcum powder, can any lawyer then just find a client and bring them in and get some money from that settlement, or is there some filtering process of, who can have a case that would be applied to that fund?
Well, yeah, so we have to be careful what we're talking about. I don't know of any massive fund set up for talcum powder at this point.
I may be wrong.
That may be something.
Let's use the asbestos. I believe they did that.
Yeah, and that's somewhat complex because there's many different defendants and many different types of plaintiffs. But I would say that what's happened in the past, if there's a bankruptcy, for example, the bankrupt corporation creates a fund, and let's say there's $1 billion in the fund, and then people that are victims of the product that they sold can then appeal to the fund and say, yeah, I was exposed to this product, I have this disease, I can prove it, these are my doctor's reports, here's my evidence, and then the administrator of the fund will pay out the claims according to however that's been agreed to.
And before we close out, let's talk about one of the things. Now, I grew up in Missouri. We have judges who are appointed. Here, judges run for office.
Yeah.
And the court system, should be viewed as nonpartisan. I mean, they're the referees or the umpires, you might say, of the legal system. What are your thoughts on, should we go to a different system instead of electing? And of late, and by late I mean maybe over the last 20 years it seems like, the cost of running for the Illinois Supreme Court has really exploded, with the trial lawyers putting in a lot of money, with other people who would oppose positions as an association, whether it's the business community, let's say, putting in a lot of money to support their candidate. What do you make of the system? I mean, and what about the taint that it might leave for a lot of Illinois citizens that go, is justice for hire?
Boy, it's a really interesting and complicated question, and if we can do a whole nother show on that.
Yeah, you can probably spend an hour.
So the first thing I'd say is, there's some famous politician once said, I'm in favor of a system of appointing judges as long as I get to do all the appointments, right? So that's the problem with an appointed system, that unless we all figure out who's going to do the appointing, everybody worries
well, it would
that
be
it
the
won't
governor.
be fair.
I mean, typically, if we went with the Missouri model, a lot of people looked at the Missouri model.
Yeah.
Typically the trial bar would say, here are 8 candidates for a position or 4 candidates for a position. We find them all to be qualified, and then governor can.
And he has to pick from that list?
He can pick from that list, or he could actually say, which the governor of Tennessee did a couple of years ago, say, I'm not picking any of these guys. I don't like any of them.
So that's what you worry about,
Bring
though,
me
right?
back a new list. But at least in that case, the governor, just like the president, of course, the presidential campaign is we're having right now happening. I mean, one of the main arguments is, but who's going to be appointing the judges to the Supreme Court? So it works that way at the federal level. I mean, the president appoints. Should we have a system, in your estimation, where the governor's appointing, and maybe again where it's filtered through some of the legal community to say, here's some candidates?
So there's
and
really,
if not, what's good about the current system?
Okay, the problem with an appointed system is who's doing the appointing. And so There's always going to be issues with a particular interest group controlling the appointments, and that's a problem. If it can be solved, and if Missouri solved it, I don't know. What's good about electing judges, and not everything's good. I mean, some elected judges are not as good as others. But what's good about it is that everybody, without regard to whether they're an African American or a female or some other minority group, has a shot to get in and get elected. You know, if for whatever reason the person appointing chooses only to appoint white men, we have a judiciary that's not representative of our community, and it wouldn't be fair. So the elective process allows everybody to get a shot at getting into those positions. I don't think there's a perfect system. You're going to have judges that maybe aren't as good that are appointed. You may have some that aren't as good elected. You have some great elected judges. I mean, I have nothing but respect for our judiciary in this state, and I think the system works well. Find me a perfect system. I don't know if there is one.
Before we close out, let me just give you the opportunity to make a summary, which, yes, as an attorney, you're certainly familiar with doing. Let's just summarize. What would you say are the for all the criticisms that people point to the Illinois trial lawyers, what would you say in general to say, here is the reality of our association?
Well, you know, I guess one of the criticisms I've heard is that we donate money to politicians, and then I look at a situation where our Governor Rauner, is a billionaire who has put $20 million of his dollars into giving money to politicians. So he wants a system where we are not allowed to give money to politicians, but only he is. And I'm not okay with that. You know, frankly, no one would be happier than if money was completely out of politics as far as I'm concerned, and if it was publicly funded elections. But until we get to that, you know, you can't allow one side to give their billions of dollars to public officials while the other side has no chance at all. And let me make this point: the trial lawyers will never be able to come anywhere close to matching the money that Governor Rauner and his friends have to give to Illinois politicians.
All right, well, Chris Hurley, we appreciate you taking the time to explain these policy positions, and best of luck to you.
Thank you. Thanks for having me. It was fun.